Number one.
None appears on behalf of the writ.
Number two.
The advocate appearing in this matter, my lord, is on his legs, my lord. He's about to reach court. He's just stuck, my lord. If it may be passed over for 15 minutes, my lord.
Matter is listed. application.
But the issue is, my lord, I am not appearing in this matter.
Then you should have asked him what he has sent you for.
If it just maybe
Can't take the court so lightly. Yesterday he made a mention that it's for extension. We, without saying anything, we said take the slip. He is not here. We are looking at the record. There is no application for extension. Interim order lapsed on 6 July. What do you expect?
lord is
Your Lordship, extreme order is still on 10 July it will expire.
Huh?
10 July it will expire.
By which order? Read.
Previous order. On previous occasion, I have mentioned that the interim order will
So
expire.
therefore, that is the date, just because you mentioned.
No, the item was
Where is that date, 10 July? In which order? The court proceedings are the most casual thing in the world.
(24/6).
Yes, just read the order, please. Today is 10. Very well. We are, our attention is drawn. It will come for consideration after 2 weeks. Leave home a bit early that day.
Number 3.
Lordship, I'm appearing for the state. Lordship, in this matter, this is regarding the diaries of the advertisement of surgeon and armed police sub-inspector. Mr. Roy had called me last night. He's not well.
Okay.
He told me
Yes, my lord.
what.
Lord,
That-
I am led by Mr. M. Roy.
That is,
He is suffering from sore throat.
Lordship, it will be, could it be on Tuesday, Lordship? I might.
Next.
Whatever the next date and not on Monday.
No, he is unwell. We don't
He's
know.
unwell. And that is why he told me he
Let's
requested
take it
me
up after the next week.
after the next week.
Yes.
Let-
We are informed that Mr. Roy
Number 4.
here.
I'm appearing, but well, Lordships had called for instructions. She's also asked for it, but as she's not here, I'm not in a position to play. Lordship will kindly keep it not
Today only.
Not,
We are
not
not adjourning it. Let's try to find out by
I'll
Monday.
just, I'll check. No, I'll check it.
No, there is incessant rain, so therefore
Yes,
there
sir.
may be people with difficulty. We are aware of that. But
Then Lordship Tuesday, show me
Tuesday. On Monday, month will be passed.
let it be.
Obliged. Let them come.
Accountant General.
Okay.
Not today.
Oh, then very good. Then please go.
I'm appearing for the Accountant General Lordship in this matter.
Okay, very
Usually instructing.
good. I-
Now 5.
Get. Most probably this bench may not be available on Monday. Most probably.
No, 5, I'm led by also, my lord, Mr. M.N. Roy.
Same order as the first case. Second case on the ground of Mr. Roy.
Grateful, my lord.
Number 6. I'm for the petition, my lord. My lord, my brief is. But I'm having.
No, you are required to file some supplementary affidavit.
My supplementary affidavit is ready. Then. Yes, sir.
ना ना कॉपी दे उन्होंने ही फाइल ना प्लीज ना कॉपी
Josh has
सर के सर ओरिजिनल तो बोलता है ना
Matter is adjourned to make sure you have the service done by Monday so that
We have served, but in the GP office. That is the problem. Number 7.
which has not filed. Which is not ask him why it is not. You- None appears on behalf of the applicant.
Number 8.
I am appearing for the petitioner, praying for not to delay.
Nine. Yes, yes, they can break when we get on at 12.
DCL, my lord.
Yes.
Will it be, my lord? On the earlier occasion.
Number 11.
I am for that. Now, this is a matter where I have challenged the order passed on 13th January 2021. It's a case of a splitting of load. The learned first court was pleased to pass the order at the motion stage without granting us opportunity in filing affidavit. This is my first point. And so far, the second point is, if your lordship kindly see the order itself, where the Honorable First Court was pleased to misinterpret the provision of Regulation 14, lordship. May I place the Regulation 14 before your lordship?
Just give us 2 minutes.
Lordship. Wait.
So it's not been complied yet. It has not been complied yet. Yes, what do you want to say?
If your lordship kindly see the order itself, impugned order for the time.
No, that's what we were reading. Where is the provision that you are
I will. But lordship was pleased to say that he is not the registered consumer. If your lordship kindly see.
Yes, we have seen that.
Yes. Now lordship kindly see I am sorry.
His lordship is of the view that this will not prejudice your revenue because it will amount to a kind of a new connection.
Lordship.
Therefore, he said that to proceed
Yes.
to give a quotation.
Yes.
You say it is a splitting which cannot be done.
Lordship.
Yes.
I'm deeply obliged.
Yes.
This is the scenario, entire scenario.
Yes.
And on that basis, on the basis of first applications, we have made an inspections. And we found after inspection that she is already getting electricity from the existing meter, lordship. That we have already.
Same petitioner.
Same petitioner.
She is getting, or the meter is in her name?
Meter is in the name of her father. And there was a divorce, and she is now at present.
It's not the
No,
point.
no, 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 I'm
Whether
not on
there is an existing connection
Yes,
in
there
her
is an
name.
yes,
In her
existing,
name.
not in her name, in the name of her
So there is no connection in her
no
name.
connection.
To
And
that extent, the single judge is correct.
I tell you, lordship, so far the regulation is concerned.
So now let's see the regulation.
Yes. I'm extremely sorry, I have got a one copy also. You can without the bed koro. মা দেখতে আমি পড়বো তো পড়ে যাচ্ছে এটা পড়ে যাচ্ছে এটা পড়ে মা this is another copy, lordship, another copy. দাঁড়া। There is also division bench judgment of this Honorable High Court on this.
Did you intimate the ground for rejection?
Yes, yes.
You have intimated?
Yes.
Where is that? Show us.
Kindly see. Page. Lordship, page 30.
Again, we are asking you, did you communicate the reasons for rejection?
So far, we have seen that on that basis, we have given the communication, the reason supply regretted for supply. This is our original CSC style, that whenever there is an.
You are not concerned with your style.
No, Lordship.
You may be having a style totally divorce the provision.
Lordship.
We will not sustain such a style.
Lordship.
What the provision mandates, that is to be seen. Therefore, we asked you, did you give the reasons for rejection?
Page 30, Your Lordship, where it is reason.
Just show us what is the reason in support of the decision to regret.
Then the Lordship, then keep it up on another day. Lordship, I will show the letter whether that has been given or not.
No, you have to. Then why you have challenged? We don't know.
So far splitting of load is concerned, Lordship, High Court division bench has repeatedly held that it has to be decided by.
That does not mean you will proceed to do whatever you want and come to the High Court and say that there is a division bench judgment. You are obliged to act in terms of section Rule 14 or Regulation 14, whatever it is.
Yes, Regulation 14.
So you are bound by it. Not only the consumer.
Lordship.
You have to strictly adhere to the provision.
I bow down to you.
So it says that there may be an occasion to gain advantage of a lesser charge, because if there is more load on one meter, the charges will increase. So we understand what you are trying to say. If there is pilferage of revenue, then it is your concern. But you can't act like this. You are not a monarch. No, regretted.
No, absolutely not.
Then,
absolutely not.
Yeah, the regulation said you must communicate by reasons. Where is that reason?
It has not been annexed to the writ petition, so I will.
Are you sure? We'll record that.
Let me take instruction, Lordship. 2000.
We have put a specific query to the learned advocate for the You will be
Lord,
totally different.
He said 2020, all on a sudden matter appears. I just jungled on and come before your Lordship. I have to get prepared myself, Lordship. I'm sorry for
Such
that.
instructions you can get over telephone.
No. So far I have called them, Lordship. So far the instruction which has been fallen from your Lordship.
No,
I will
because that is the provision you are relying upon.
I
You are
fully
relying
appreciate.
on that provision.
I
We
fully
understand the concern of the regulation, and whether if that concern is there, you as an officer of the corporation are required to take steps in accordance with the regulation.
Lordship.
Can't behave like this and make the consumer suffer.
No, not at all, Lordship.
Let's see what it is, whether we have acted with within the regulation or.
I'm keeping it.
Item 12.
Your Lordship was pleased to return me after 1 week.
After 1 week. Till now, there is no notice to the writ petitioner.
Initially there was given, but at present no notice.
So they have already entered appearance.
I don't know whether I have to check it out.
Anyway, let's see you file the
As a
supplement.
Lordship.
None appears. You have the appellate. Number 13. Demo. Now 14.
Stay more.
Fifteen.
15th, my lord, I am for the writ petition or appellant, my lord. This is regarding, my lord, the waiver of loan, my lord, that
Waiver of loan.
loan, my lord. The honorable court heard the matter, my lord, and sent the matter to the mediation, my lord. My lord, but mediator was not taking decision, my lord. My lord, during this period, my lord, petitioner paid, my lord. The petitioner is the wife of the, my lord, the taking loan person, my lord, because, my lord, he is the assistant teacher, my lord, he taking loan during he died in hardness, my lord. His only wife and, my lord, the minor daughter, my lord, not able to pay the amount, my lord. So, my lord, so applied for that, my lord. My lord, the mediator was not taking any steps, my lord. So, my lord, during this period, my lord, principal amount was paid. My lord, regarding interest, my lord, your lordship adjourn the matter, my lord. I take further instruction, my lord, from the petitioner, my lord, and service against the all person, my lord.
What is to be done in a writ proceeding? You tell us for what it is to be kept pending.
My lord,
We direct that she will not pay any interest.
yes, my lord, that is.
We can direct. We don't think so. We don't think so. We cannot direct.
My
In a
lord,
writ
kindly
proceeding.
adjourn,
For what it is
also,
to
my
be
lord,
kept pending, that we are asking you.
my lord, it is a not for banking loan, my lord. It is, my lord, the
Whatever it is a loan, it
Kind-
is governed by the terms of the contract. It is not open to the writ court to look into
he's the
such.
assistant teacher, I mean, taking loan, my lord,
You have taken loan from the bank. Why you are saying it is not a bank loan?
a cooperative bank, my lord.
Whichever bank, it is a bank. Where is the question? Sorry. Lord Learned Advocate for the writ petition.
into the Lok Adalat, Lordship. These things are decided. He might get some relief there.
I am ready and willing
The
to
next
any
national
her mother because
Lok
her husband
See,
her husband was a cancer patient. He
we cannot pass an order based on sympathy.
yes, ma'am.
Keeping the matter pending is only to keeping a hope alive, which may not most probably crystallize into anything. The sooner the writ petitioner knows the status, the better it is for her, because she will have to ultimately take steps in accordance with law. We can't pass an order on sympathy. Please try to understand what we are saying.
To
If
consider
there is any way you want to go to the Lok Adalat or there is some option, we can
Might
say
get
that
some
you avail
relief
that
there.
opportunity. Keeping it
That
pending is not going to help her. It's not going to help anyone. It will just add a docket to the court's pendency for no purpose, futile exercise.
that is
So therefore, we are asking you if you have made a representation, if you want to avail the remedy before the Lok Adalat, you can
That
do
is
so.
better.
We can dispose it off in that
I-
term after some argument.
Lordship, it's in the Lok Adalat. If this matter is taken to the Lok Adalat,
Oh,
if your Lordship disposes it off,
all right.
then it becomes a problem with the Lok Adalat.
So we should refer it from here itself.
If it can be referred, if he agrees, then it
Yes.
can be referred and
yes,
they
yes, ma'am.
will call the bank and it can be,
Yes, ma'am.
it might be sorted out. There might be a hope from the Lok Adalat, Lordship.
So we refer it to the High Court Legal
I
Services.
think, Lordship, then he might get.
The writ petitioner is
Number 16.
in order as was passed in the earlier case. Appears after 1 week. Take the appearance of the Leonard State Council.
Number 17.
Same. Item 18.
Have been treated as an applicant of the state. And for the limit is mispaid and misplaced. If she is not a
It is your appeal.
He is a contemner. Appeal filed by the state.
The contempt appeal arising out of contempt. That is
Learned AGP submits that he will.
the contempt.
Let the file be sent down to the department. You do whatever is required. You want copy, whatever, we are giving you 3 weeks.
No, 19.
19 is also appealed by the state of West. Then I put
What is your ground in the appeal? The single judge has said that he will return whatever he has taken as a benefit, and then only the pensionary dues will be processed. Why you have preferred that? And if he fails to return, then he will be liable for interest.
he just take down the details of the appellant, see if I can get instructions, and then otherwise. This matter, Lordship,
As paid by the learned AGP. To the department, you want to take copy, whatever you want to do, we have given you 4 weeks time.
yes. Certificate copy of letter.
120.
There is none to represent the appellant. Yes, same order.
Good, item number 2.
Yes, sir.
My lord, item number 22, my lord, the advocate on record for the appellant has not come to court. My lord, I am praying just not today.
All right, not.
Grateful, my lord.
Same order. After 1 week.
Then 24.
Same order. Yes, same order.
Non appears on behalf of the appellant.
And 27.
Yes, none appears. 1 week, same order.
Okay. Yes, none appears after 1 minute.
There are 29 in fact because was because we were security guards engaged to look after the FCI go downs. Yes, removed by other set of employees. Now it
Yes.
has become in.
If we are informed by Mr. Swenson.
I'm grateful. 30.
What is our first of all, what is
31.
In case I can't.
This is by you.
Appeal by the state, yes.
This is your appeal about, let us see. Have the file sent to the department.
Item 32.
I'm seeking for a week's adjournment in this matter. I'm seeking for a week's adjournment in this matter. The EOD is suffering from personal difficulties since his
We
father.
can't hear you, sir. Please.
The
Ah.
the EOR is suffering from going through some personal difficulties since his father-in-law is in deathbed, my lord. Kindly grants a week's adjournment, my lord.
As paid list after 1 week.
Grateful, my lord.
Give an appearance.
Item 33.
Same order 1 week. Same order after 1 week.
Item 34.
Same order, but after 2 weeks, not 1 week. Now all the matters after 2 weeks.
Item 35.
Appearing for the appellant in this matter, the university.
Yes. Yes.
My lord, for hearing of the matter, my lord, we have not filed any application for stay. We filed the appeal. My lord, we tried to get the matter hard upon the appeal on the points of law. So, if my lord so pleasure that I can serve a notice upon the other side, Lord, she's kindly can me, but this is an appeal. And we
Not required. We are hearing you. Let me, if you make out a case, we'll direct for service of notice.
then Lord, she's kindly make this only not this week,
Not
Lord, in
today.
this,
Yes, it will come in the next week.
not this week, my lord. We shall come prepared for
We come on
hearing.
Friday.
Grateful, my lord.
No notice is required. If you make out a case, we'll
Yes, my lord. I
direct.
shall first place my
Yes.
appeal there.
Madam 36.
My lord, adjourn for 10 days.
Why, sir? Why?
Dinner is not. Yeah.
Not today only. You do whatever is required. What order you have challenged? An adjournment order? Not today. 10 days adjournment.
Madam 37.
None appears 2 weeks.
Madam 38.
None appears 2 weeks.
Nine.
Ask him to dust it. Ask him to dust it. See that. Two weeks. None appears.
40.
Same on. 2 weeks. 2 weeks.
Item 41.
41, I appear for the petitioner. This is against LOC.
NOC.
LOC, lookout circular. And I'm the bank. At my instance, LOC was issued. They came up in the writ petition, it was quashed. But we have come up in appeal. And this has come probably without any of us knowing this matter. This has come suddenly. And kindly takes up after some time. My lord, I would also beseech your lordship to kindly grant me liberty with an extension of further 2 weeks. My lord, there was a direction on me to use a supplementary affidavit by the last order. And if your lordship so pleases, kindly grants me a further extension of 2 weeks.
You have asked for issuance of LOC against the defaulter.
Yes. There are various decisions of different high courts, but at least to my research, I could not find any concrete judicial precedent from the apex court. There are very many of different high courts, which in my humble submissions are contrary to each other in some sense. Our high courts had maintained I should admit that had maintained a persistent view that LOC should not be used at least for recovery purposes. At least our high court has maintained. My lord, I would beseech your lordship so that I can get an opportunity to invite your lordship to consider this.
No, there was some direction. Oh, you were also to file supplementary.
Yes, I am.
What is it you want to bring on record?
Most probably.
Yes.
Most probably, there were certain central government circulars which I ought to rely upon.
So for that, you need not file a supplementary.
But I had been given the liberty. Further 2 weeks be given, if not required, my lord, we will not use that. However, he has to use an affidavit to my appeal.
Opposition to the stay.
Yes, opposition to the stay. The appeal can be taken up for consideration and can be heard.
Yes, that's what we are thinking. Why? Where is the stay?
That stay is there, but application for appropriate order, it cannot be in that sense because they have in the meantime traveled several times abroad and come back.
Come back. All the more reason.
They say that they have gone.
He is still here.
The problem
After this order was set aside by the writ court, on which year? In which year? In 22. 4 years later, he is still here.
He is still going and coming back.
Obviously.
But
so just see what you are trying to do. As prayed. As prayed. All right, 24th is all right. 24th is all right.
Huh?
42.
42.
None appears. Just after.
Item 43.
Same on.
Item 44.
Lord, I am for the WBSCDC. Not for WBSCDC.
You are for WB. SCDSL.
SCDCL, my lord, against the order passed by the learned single judge with regard to the theft of electricity. We have, my lord, against the theft, we have issued assessment. The learned court says that yes, unless appeal is preferred, this writ petition is deserve rejection, it is dismissed. That's because there is a provision for preparing an appeal.
The learned advocate for the WBS.
Hmm. 2 weeks. Grateful.
Item 45.
Your Lordship, on instruction, I'm submitting this before Your Lordship. The advocate on record for the appellants are due to some unavoidable personal difficulties, Your Lordship. He is unable to appear before Your Lordship.
Not today.
'46.
None appears on behalf of the appellant.
'47.
Same order.
'48.
Ah. No order. Same order. Just see if there is an earlier order, then pass it on. There is no earlier order. If there is an earlier order, then give it, otherwise same order.
Mr. Naik is for WBSCDCL in this matter. Your Lordship fix the matter.
Give the appearance. 2 weeks.
Item 49.
Same order, no, none appears. Matter stands adjourned 2 weeks.
Item 50.
I am for the appellant, my lord. This matter, my lord, appellant number 1 died, my lord, an application for substitution in file, my lord.
Substitution.
Yes. Appellant number 1 is died. Within time.
who is for the Union of India.
Appellant number 1 was the writ petitioner.
One is that, man.
Was the writ petitioner?
The other is
Any other writ petitioners?
other is there, man. There are 7, 8,
Sir, on the Union of India.
8 repeats, man.
This is the Calcutta. Check it with the team. Don't know whether they have filed.
Can 1 is the substitution. There is only one copy in our file.
This is my lord, only one copy in file, which is heard by the Registrar General, my lord, Registrar Administration. This jurisdiction of the application within time. It is in file within time, my lord. This is only one copy has been filed, my lord.
So
I have other copy, my lord. I can file.
please give it, yes. Serve on the Union of India.
It is within time, my lord. Let me substitute the name of the legal heirs of the number 1. It is within time. It is not.
Application is filed for substitution.
Legal heirs of the original writ petitioner. They are the Manoj Palmer and others, 7 others.
So they are already substituted.
No, this is the in writ petition. They are substituted.
So again in appeal, they have to be substituted.
No. After filing this appeal, that is appeal number 1, that.
They substituted,
Yes, substituted appellant.
who has died? Mr.
Manoj Parma.
Manoj Parma. The application for
Just first time.
no, we have gone through the entire order.
Yeah, there is
Whether
only
the
interest,
whether
only interest area rent has been paid, my lord. In person the order of this single bench, my lord. Honorable
2 crore or something 82 lakh was the areas due.
Kindly fix any other date.
What date, sir? There is only one issue. Whether this act will prevail or the chief.
Let me serve the copy.
Or, no, not required. If you want to make out a case, we will direct for issuing notice. If you don't make out a case, we will dispose it off.
Kindly attend for 2 weeks, my lord. I shall.
Why 2 weeks, sir?
I am not ready today. Today, just in morning, I have seen the list, my lord. This matter is appeared.
The matter is adjourned for the day for consideration of. In the determination by the commissioner, he has said that there will be a set off of the taxes. Act says the taxes cannot be set off. So which will prevail, the act or the chief commissioner's adjudication? That is the only issue.
I'll fix on 20th, Monday.
It will come on Friday.
Next Friday, I have some difficulty.
You have difficulty?
I will not be there.
Just after 2 weeks. It will come in the Friday after that.
Order 51 and 52.
My lord, I appeal for the appellants. My lord, there are 2 appeals, but one arising from the parent order of the writ petition and one from my lord recalling application taken out by the appellant, which was dismissed against that. My lord, both have a section 5 application. There is a condonation of delay. In the main appeal, my lord, a delay of possibly 44 days, to which my lord opposition and reply has been filed already. And in the recalling application, there is a delay of around 140 odd days, to which my lord I believe there is no opposition as yet. Now, my lord, the main order, I tell your lordship, in the writ petition, my lord, the learned judge has directed the regularization of the writ petitioner. So, my lord, the Calcutta State Transport Corporation is the appellant. My lord, is agreed by that, in fact, the order of regularization. My lord, if your lordship, I believe 51 is the appeal against the recalling. But,
the applications for condonation have already been disposed of.
No, my lord. The recalling application, I believe there is no opposition to it as yet. The main writ application is application for condonation, my lord, opposition.
That is can 1.
That is can 1 in both.
Let's see can 1 first.
My lord, lordship is taking up item number 51 first. 51 is the recalling. My lord, I will be praying before lordship to take up the main matter, main writ application, which is the next matter. 51 is the main matter, right? I'm obliged to your lordship. Can he takes up can 1?
MAT 2059.
Lordship 2059 to lordship. এটা তো মেমো দিলি আমাকে সেখানে এটা বললে এটা মেমো লেখা কোথায় রেখে বলছো
So you did not appear before the single judge?
Did not. That is what necessitated the recalling application, the next appeal. But I tell your lordship, I have ascertained the facts why they could not appear. But it appears that, my lord, the affidavit was ready, which has been annexed to the stay application also. But my lord, I do not know why, due to misconception, it was served upon another learned advocate who normally appears all the time against the Calcutta, against the corporation. As a result, my lord, the grounds have been stated, they did not appear. That is admitted. Well, that is what necessitated it. But if your lordship takes the merits of the matter, but a memo has been relied upon of 1979 and regularization has been directed. Now, but I need not submit your lordship after the Umadev and the plethora of cases, not only regularization is not necessitated, the memo itself does not say regularization. If your lordship, my lord, allows me, I can place that memo and these.
Just give us
Lordship.
44 days.
44 days.
So there is a 44, you are opposing 44 days delay. We delay the application for condonation.
Stay application, page 69 is the impugned order. Dated 1st of August 2024.
We have heard this matter earlier. I
Lord, my learned junior had placed it on last Friday. But I was on leave. Genuine.
Yes.
Now, my lord, the first point is that, my lord, the petitioner was appointed in a post which was not sanctioned. Now, if your lordship sees, kindly turns to page 72, the internal page 4 of the judgment. My lord, the learned single judge, my lord, has referred to a memo of 1979, if your lordships have got it. Page 72, my lord, internal page 4. Now, this is the basis of the regularization granted. Kindly see the third paragraph. It is pertinent to mention herein that the relevant portion of the memo dated 3rd August 1979. Well, kindly takes the trouble of turning to that memo itself.
No, he has in 2002, he was appointed as driver cum conductor. He was sent on training. He says that thereafter you had the option of stopping to take work, but still you have continued to take work.
Lordship.
This has weighed in the mind of the writ court to direct for regularization.
That is, I'm deeply aware. That is one part. The second part, my lord, after weighing it in the mind, the clinching it is the 1979 memo.
Yes, that is one aspect. He has referred to the 79 memo.
Now, my lord, my
which contemplates after 3 years.
Now, my residual submission is before going to Madhavi itself, the 79 memo itself does not visualize that. Lord, kindly takes page 56, which is the memorandum. My learned single judge has quoted that, but I would take your lordship to the main memo itself. Page 56 is the memo. My lord, kindly turns to page 57, which is the relevant clause, clause 3, which has been quoted. My lord, may I place it?
Yes.
No, Lord. Casual and such other categories of workers who have been engaged in a perennial type of work. Well, kindly first mark this perennial type of work for a continuous period of more than 3 years may be absorbed in the regular establishment on temporary basis. So, my lord, if it is a perennial work, which, my lord, I take it that the petitioner had. More than 3 years, I take it he has. So, in that case, he may be absorbed in the regular establishment, but on temporary basis. So, my respectful submission is this: the 1979 memo only envisaged regular
conferring a temporary status.
I'm deeply obliged, your lordship. Now, my lord, that cannot be taken to be regularization per se. Now, my lord, vis-a-vis this, kindly turns to page 72 of the judgment now.
72.
And page 72 is the judgment. Well, the internal page 4. Now, vis-a-vis this memo, kindly sees at page 72, the learned judge, my lord, quotes this clause 3 of the memo. Now, my lord, kindly turns over to the next page. The first 2 paragraphs, my lord. Considering the entire situation of the case, it appears to me that necessary direction is eager to be passed. It appears from the memorandum of the Labour Department, which is 79, appears that casual and other categories of workers have already been engaged in the perennial type of work for a continuous period of more than 3 years, may be absorbed in the regular establishment on temporary basis. That has been quoted also in the existing vacancies. Then kindly sees, after quoting this, how the learned single judge proceeds. Considering the entire aspect, it appears to me that such writ petition is meritorious. One, and the same is allowed as there exists no embargo for the absorption of the present as a regular employee of the corporation. One, in my full submission, my lord, possibly since we did not appear, we could not place the actual fact that this does not exist. It only envisages a temporary granting of temporary status. And now, my lord, lordships are aware of come with the decision of the Uma Devi and then Dayanand, which clinches it. But if your lordship allows me, I can place the case. But your lordships are aware that, my lord, regularization cannot be granted.
The other aspect is we have come across circulars and notifications in the state government.
Lordship.
We don't know whether they are applicable to the state transport corporation.
Lord, I was coming to them deeply obliged. My lord, now kindly takes the trouble once more to turn to page 56, which is the memorandum. I'm sorry, I should have placed it then and there. Page 56, my lord, kindly sees the subject.
Yes.
Principles to be followed in the matter of absorption of casual and such other categories of workers under the state government. For the Calcutta State Transport Corporation, prime office is not covered by this
We
at
are
all.
asking you another issue.
Lordship.
We have come across decisions of the state government of conferring some kind of security of tenure and some benefits to persons who have.
I'm aware.
So, is there any such scheme applicable
But I
in
take
your?
lordship. So, vis-a-vis prime office, what I can recollect. Well, initially, there was a notification of 1991 granting emoluments to such casual workers.
Yes, leave and all other emoluments akin to a permanent
3
employee.
conditions were there. One, as far as I can recollect, it has to be 240 days a year.
Yes,
for a period of 10 years, continuous, and there was a cut-off date. Then the subsequent notification enhanced the emoluments.
Yes, there are 3. Thereafter enhancement twice or
Enhancement in
thrice.
February 20, last in February 2020, 21 or 22. The emoluments were regarded, but the 1991 memorandum. Till 60 years of age, my lord, I'm sorry.
Is there any such scheme applicable to the corporation?
But I will not make a submission without knowing it. But those emoluments gave the protection of 60 that you will not be discarded till 60 years of age. But
no
this petitioner
pensionary
is
benefit.
no. But I cannot, if it is not sanctioned and not regular. Remember, this petitioner over here, subject to correction, has worked till his superannuation, till 60. If your lordship wants, my lord, and come back with that instruction.
No, but then it will be of no avail. It will become a pointless exercise because that security of tenor he does not need.
He does not
He
need
has worked till his age of
till his
superannuation.
He has.
Yes.
Subsequently,
ষাট বছর অব্দি কাজ করে নিয়েছে।
I read petition.
I've annexed that in my stay application. I've annexed the writ petition.
Yes, I'm grateful to you for this. Lordship, we come to the writ petition of mine. Lordship,
Page 24 of the writ. 24. না না তুমি এই পাতাটা কাটা তো এই দেখো
কোনটা?
এই যে
মানে তুমি যেমন করে একটা লিখেছো যে মানে কি তার জন্য
ও করেছো তো তুমি আমাদের বের
আমি
করে
করেছি
দিচ্ছ
না এই দেখো না
এটা এর আগে এর আগে এই এটা খোলো এরপরে এফিডেভিটের পরে পাতাটা পাল্টাও এদিকে এসো আমাকে দাও
কি করে
তুমি কোনটা নিয়েছো কোনটা নিয়েছো অন্যটা অন্য হ্যাঁ এইটা দেখো
Yes, you have welcome. Petition murder. Page 18. Page 18. Page 18 is the petition start, and my first annexure is
39.
39.
Page 39.
39. Terms and condition in respect of offer of engagement as daily rated trainee worker for the post of driver cum conductor in Calcutta State Transport Corporation. You can see. Now, my lord, he will be placed for daily rated trainee worker for the post of driver cum conductor on purely temporary basis of no work, no pay. His training period will be initially for 3 months from the date of joining in the depot, and the same may be extended for another term of 3 months on his satisfactory performance during the initial period of training. In no case the extension of training after second spell will be allowed. He must be regular and punctual in attendance sessions on the date of his report sessions. And my lord, your lordship, it is for the training period driver, your lordship can see. And my lord, question of absorption. My lord, I will come to that. Quest 40. Question of absorption in regular establishment would be considered as per provision made under GO number 1700 Sasansa, read with circular number Sasansa, as you all have seen. But the question is, this CSTC, my lord, is a corporation under the government, and this has been formed, my lord, under the Road Transport Corporation Act.
And my lord, your lordship, it is in the act, it is then formed and it is a government corporation. And your lordship knows that government is should be a statutory body, and this should be the limb of the government, and the government should be a model employer. It's a limb of the government because it is a statutory body, and government is policying this. Government is writing that you will be given on 1700. Now they are coming. No, it is not. It is not. Then I am a poor employee. I am poor employee. I have not bargaining power. I have the reasonable expectation that after that completion, I will get the job. Now you are saying no, it is not applicable. Then you have cheated me. Then 21 applies, but 21 of the article of the Constitution. But they say that you will get. Now they said you will not get. This is false. This is false. This is not applied. You can see this is the thing. Not only that. Your Lordship can see (2005), page 45. What they write? With reference to his office number such and such, they are undersigned is directly to request him. That is Michael. To please ask Sri Bomdeshpal, daily driver come conductor number 6 of his unit to continue his training and to improve his performance after 3 years. And my lord, your lordship kindly see next page 46. In the year 2014, this is for your kind information that 5 daily employee of Manikala Depot admitted joint representation praying for absorbing in the permanent post. In the year 2014, my lord, after 9 years, they did not do. This is unfair labor practice they are doing. They are the government authority. They are doing after 9 years. They are not absorbing them. But you will assume that in a transport corporation, my lord, the driver, without driver, it cannot function. There will be big heads on the top, but without a driver, the car cannot run. And they are being deprived by them. Then they are saying it is not applicable to you. And not only that, this, my lord, 2021 or 22, he worked as casual driver. It is not, my lord, admissible under the law. And I am showing you, lordship. But yesterday I come to no. Well, Supreme Court says this is not permissible. May I read the judgment? When public institutions depend day after day on the same hands to perform permanent tasks, equity demands that those tasks are placed on sanctioned posts and those tasks are treated with fairness and dignity. The controversy before us is not about the rewarding irregular employment, but it is also not irregular appointment. It is not about whether years of ad hoc engagement defended by shifting excuse and pleas of financial strain can be used to deny the right of those who have kept public institutions running. We resolve it by insisting that public employment should be organized with fairness. reasoned decision making and respect for the dignity of works. My lord, kindly for case 4. The factual background of the said case, my lord, what was there? What was the case of before the Honorable Supreme Court? The appellants were engaged by the Commission between 1989 and 92. Appellant number 1 to 5 served as class 4 employee peon, attended duties, and appellant number 6 served as driver class 3. They were paid as daily wages and with effect from 8/4/1997 received consolidated monthly amount such and such. While discharging ministerial and support functions during regular office hours, the commission established under the UP Higher Secondary Services Commission Act 1980 possesses large recruitment cycles for teachers and principals and requires ministerial support for execution of the applications dispatched and connected as principal. On 24/10/1991, the commission resolved to create 14 posts in class 3 and class 4 and sought sanction from the state government. On 27/12/1997, the estate sought particulars of daily wages and their service details. On 11/2/1998, the commission furnished a list of 14 daily wages which included the present appellants. On 16/10/1990, the commission reiterated its request seeking sanction of 2 posts of driver and 10 posts for peon, mali, chowkidar, adverted to administrative expense and referred to earlier correspondence. By letter dated 11/11/1999, the estate rejected the proposal citing financial constraint. Madam, your lordship kindly come to page 4.5. On 24/4/2005, the High Court directed the Commission to send fresh recommendation for sanction of appropriate Group C, D post and directed the state to take a fresh decision thereon. In the meantime, having regard to the appellants' long engagement, the Commission was directed to pay them the minimum and applicable pay scale. Pursuant thereto, a fresh recommendation was sent by the communication by dated 25/11/2003. The state denied sanction, again citing financial grounds and a ban on creation of new posts. By judgment dated 19/5/2009, the learned single judge of the High Court dismissed the writ petition, holding that no rules for regularization in the commission had been shown and that even assuming the 1998 regularization rules applied, there were no vacancies for the appellant. Moreover, the learned single judge held the regularization was impermissible in view of the law declared by Secretary of State Karnataka and others versus Sumadevi and others and allied precedent. It also observed that the petitioner had not specifically assailed the subsequent decision dated 25/11/2003. The appellant preferred a special appeal number 1245 of 2009 by the impugned judgment division bench of the High Court upon the dismissal, observing the appellants were daily wages, that there were no rules for regularization in the commission and that no vacancy existed for considering them. Agreed by the order, the division bench of the High Court, the appellant have approached this court in the present appeal. The question before us is whether the High Court erred in failing to adjudicate the appellant principle, challenging the state refusal to sanction post and treating the matter as a mere plea for regularization. And if so, given the appellant's long and undisputed service, what appropriate relief is sought to follow from this court? Having heard the learned counsel for the parties and perused the record, we are unable to endorse the approach adopted by the High Court. The original writ petition before the High Court expressly assailed the state refusal dated 11/11/1999 to sanction post for the commission and sought a mandamus for creation of post with consequential consideration for the appellants. This single judge of the High Court and the division bench of the High Court in appeal treated the matter as a bare plea for regularization answered it only on the touchstone of absence of rules and vacancy, and rested principally on Umadevi Sufra. In doing so, the courts below failed to adjudicate the principle challenging to the state's refusal to the legality of its decision. In our opinion, such non-consideration amounts to a misdirection and in fact a failure to exercise jurisdiction. The state refusal of 11/11/1999 cites financial constraint and the subsequent decision of 5/1/11/2003 taken after the High Court's direction to reconsider adverted to financial crisis and a ban on creation of posts. Neither decision engages with relevant consideration placed on record, namely the Commission 1991 resolution and repeal proposals, the acknowledged administrative exigencies of a recruiting body handling large cycles, the continuous deployment of these very hands for years, and the existence of attendance work that is primarily perennial rather than sporadic. While creation of post is primary and executive function, the refusal to sanction post cannot be immune from judicial scrutiny for arbitrariness. We believe that a non-speaking rejection on a generic plea of financial constraints, ignoring functional necessity, and the employer's own long-standing lens on daily wages to discharge regular duties does not meet the standard of reasonableness expected of a model public institution. Moreover, it is undisputed that the nature of the work performed by the applicants, that is, sorting and scrutiny of application, dispatch, and the office support and driving, has been continuous and integral to the Commission functioning since their engagement between 89 and 92. The Commission itself has moved for sanction of 14 posts and furnished a list of 14 for daily wages, including the appellants. That consistent internal demand coupled with uninterrupted utilization of the appellant's labor on regular office hours fortifies the conclusion that the duties are perennial. Your Lordship kindly see that he has worked for almost from 2002 to 2020. Continuous work.
2002 to
22, he has, I believe, 22 he has retired. For same post. Yes, good. Duties in pen. What Supreme Court says, this type of thing is perennial. It is permanent. To continue extracting such work for decades while pleading want of sanction extent in a position that cannot be substantiated. Your Lordship kindly come to paragraph 11. Furthermore, it must be clarified that the reliance placed by the High Court on Umadevi Sufra to non-suit the appellant is misplaced. Unlike Umadevi, the challenge before us is not an invitation to bypass the constitutional scheme of public employment. It is a challenge to the state arbitrary refusal to sanction posts despite the employer's own acknowledgement of need and decades of continuous reliance on the very workforce. On the other hand, Umadevi Supra draws a distinction between illegal appointments and irregular engagement and does not endorse the perpetuation of precarious employment where the work itself is permanent and the state has failed for years to put its house in order. Recent decision of this court in Jaggu versus Union of India and in Sripal and another versus Nagar Nigam have emphatically cautioned that Umadevi cannot be deployed as a shield to justify exploitation, though long-term advocacy, the use of outsourcing as a proxy or the denial of basic party where the identical duties are exacted over extended period. The principle articulated therein apply with full force of the present case. The relevant paras from Sripal have been reproduced hereunder. the respondent employer placed a reliance on Umadevi Supra to contend that
Don't
daily
read the entire judgment. You need not read the entire judgment.
This is it is said that Umadevi is that. You have also seen it is here. It has been clearly said. If it is a continuous service, it should be, my lord, regularized. It is a model employer, and in this case, the corporation has been formed by the statute, and government is the owner of the corporation. And my lord, your lordship, the next case is, my lord, I'm giving your lordship. Well, pronouncing, that is what is it. You can see that has been mentioned in this pronouncing. Pronouncing. In the pronouncing, they can bhul jani to say they can.
Yes, this has been quoted already.
It's quoted, of course. I am relying on this.
And you have also got Jago's case.
No, Jago's case, I haven't. But if people are interested, I will give it to you.
No, why we should say whatever you want. Why we should ask?
No. When your lordship, it is falling from your lordship, not the.
No, because this judgment has considered one more judgment.
Yes. If your lordship kindly take the next Tuesday, Wednesday, I will give it to your lordship. I will give it. Not only that, there are other appeals, my lord. Your lordship can see that also.
We don't want you to multiply judgment on the same point. Yes.
No, not multiply. They have that appeal has been prepared, my lord. The Order 9 Rule 13. They have asking. They in that they have asked for Order 9. They paid Order 9 Rule 13 to change that order to be recalled. But CPC 141 said in a writ proceeding, CPC does not apply. You have noted. That is on the basis the honorable single judge has given that passed the order, and Supreme Court has been shown before his lordship.
53.
That he has not argued yet.
No. I have
other case he has not argued yet. Yes.
But I'll take only 1 minute before she has to come back. So, but I would have been extremely happy if I would have been favored with the citation, or if it is unreported a copy. I have not been.
Dharam Singh and Jago every day.
But the first, what my learned friend was placing, but I could gather that paragraph 11 possibly of the first judgment.
We have had the occasion of going through this judgment.
Paragraph 11
in those cases, the commission itself had moved for sanctioning the
for sanctioning of the post. I'm deeply obliged.
The apex court held that the issue is not of long service. The issue is when the sanction was requested, whether on a ground of financial paucity, you can reject.
You can reject the sanctioning or non-consideration. Possibly that will not apply. Number 2, I do not know the second case cited, my lord. I believe it is Puran Pandey's case.
No, there is one of in Jago's case.
No, the Puran Pandey's case, possibly the second case. Is it Puran Pandey?
No, there is one of Shirpal and there is one of
But I am
Jago.
giving Shirpal, I am giving.
No, Puran ki bolna na Puran.
No.
Because Puran